Hi, everyone. I'm Auro Ogorian with ACap Advisors and Accountants, and welcome to another edition of the ACap Recap, where we go behind the blog and answer some of your most important questions. And from time to time, we have subject matter experts come to us and talk to us about some really important subjects that pertain to some of our viewers and listeners. Today, we're going to talk about overpayment disputes with healthcare insurance companies. And I have an expert online with us today whose name is John Mills from Nelson Hardiman. John is an attorney, he's a partner at Nelson Hardiman, and he's going to talk to us about the overpayment disputes that providers have with insurance companies. And this is an important area because most of our clients are in the healthcare profession, and if they do take insurance, at some point or another, they are going to encounter some sort of dispute with the insurance company wanting to claw back an overpayment. So, but before we begin, please remember to subscribe, like, and share our channel. And if there is a topic that you want us to discuss, mention it in a comment below or send us an email, and we'll be sure to include it in future discussions. So stay tuned, and we'll be back with John Mills. Hi again, welcome back. I'm Auro Ogorian with ACap Advisors and Accountants, and welcome back. We are here with John Mills with Nelson Hardiman. John is going to talk to us about the overpayment disputes with healthcare insurance companies. And before we kind of dive into it, John, why don't you tell us a little bit about yourself and what you do and who you do it for?
Sure. Thank you, Auro. Really happy to be here, and thank you for taking the time to speak with me about this topic. So a little bit about myself. I'm a healthcare lawyer. All of my clients are healthcare providers, a lot of doctors, medical groups, and other types of healthcare providers. That would include, we've got hospital clients, we've got pharmacy clients, laboratories, substance use disorder treatment facilities. I mean, just kind of the whole provider continuum. That's who our client is.
Okay.
We don't represent patients. We don't represent the insurance companies. We represent the providers. And we're kind of like a full service firm for providers. So we do corporate and transactional work, we do regulatory compliance work, and then what I do primarily is litigation and dispute resolution, with a pretty heavy emphasis on reimbursement disputes, which is what I'm going to be talking about today a little bit.
Okay, and you're a partner at this firm, right?
Yes, I am a partner at Nelson Hardiman. That's correct.
Okay. And the reason why I asked you to be on this is, one, I've known you for a long time. I know you're a healthcare attorney, and most importantly, we have a lot of clients who are in healthcare. It represents about 85% of our clientele. So our listing is directly, our target audience on who this may be impacting. So what I thought I'd do is kind of let you talk about some of the hot topics that are occurring with overpayment disputes, and if it's okay, I'll kind of ask you some questions along the way. That's right.
Yeah, absolutely. I would love to talk about overpayments. It's something that I've been working. I mean, it's an issue that comes up a lot for providers. I'm sure your audience who's listening, if they are healthcare providers, it's probably a certainty that they've either encountered an overpayment dispute already, or they will. And just what is an overpayment? What I'm referring to there is when a health insurance company, whether it's private or a government, although with today's discussion, I'm really going to be focused on private insurance.
Okay.
But it's where the third party payer, you call them. It comes back and says, hey, provider, we paid you money on this claim that you submitted, but either we shouldn't paid you at all and we want all our money back, or we paid you too much and we need to refund some portion of it back. That's what an overpayment is. Okay.
So when these insurance companies are asking for these overpayments or targeting a particular claim, what is it that they're actually looking for from the provider? Hopefully my question makes sense, but
yeah, no, it does. It does. And by the way, just so I should always give the necessary disclaimer. I'm just talking. This is just for my personal views. I'm not here to give legal advice to anybody who's listening. So just no attorney-client relationship created as a result of watching this video.
We always put that in the video anyway, that this is just informational purposes. It's never tax or legal or financial advice. So, although people don't necessarily listen to anyway, but it's good to include it anyway.
Yeah. So what are the insurance companies looking for? Well, they're looking for a lot of different things. There's a lot of different reasons why an insurance company might claim that they overpaid a provider. But at bottom, what they're looking for is what's in the industry known as fraud, waste, and abuse. Fraud, of course, is healthcare fraud. It's insurance fraud. It's where somebody is knowingly submitting a claim where they know they're not entitled to the insurance benefit, and depending on how egregious that is, that can rise to a criminal conduct. Waste and abuse, that's really where most of these disputes are. It's where the insurance company either it believes that the provider submitted a claim with some incorrect information, or perhaps the insurance company made a mistake on its end and decided, and they've caught that mistake, and now they want to come back and recoup the money that they believe they should never have paid to begin with. And there's a whole lot of different reasons why there could be a mistake or why there could be incorrect information. I mean, it can be everything from the insurance company believes that they've been billed for services when in fact services were not rendered. That would be an example of fraud. Or there could be a dispute about medical necessity where the insurance company says, hey, we've done a post-payment audit. We've looked at the records and we don't believe that the records support the medical necessity of this claim. We paid it, but now we want the money back. And just so people understand, in healthcare, claims get paid through electronic claim system. So, provider submits a claim for payment, and usually 30, 45 days, maybe 60 days, they're going to get paid.
That CPT code you get, right?
They fill out a claim form, they put in codes and various information that's required to be on this form. And there's a couple of different forms, but they're very standard uniform forms. And so this information is submitted to the insurance company. This kind of goes through an automatic claims processing system, and it gets paid. And the payers, the insurance companies, they rarely are reviewing information in advance of paying the claim. There's not like somebody's actually sitting there reviewing the claim to say, is this a reimbursable claim?
Right.
They actually then they do these post-payment audits where after they've paid the claim, they'll go back and they'll send maybe a letter to the provider and say, hey, we want to look at 2 years worth of your medical records in support of these claims. And then they'll do this comprehensive manual review of records to see whether the documentation supports the claim, whether it's supports medical necessity or conforms with the insurance company's billing guidelines or their coding requirements. There's a lot of different things, but at the heart of all of this is this danger that you've been paid. That's money that that you put into your back into your operation, and suddenly a year goes down the road and the insurance company's coming back to you wanting to claw back money from you, which can be very difficult for a lot of providers, because it's not like they've just got that money sitting aside waiting for the insurance company to come back and take it. So
how often does this happen?
Yeah.
How often does this happen? I mean, is it?
Well, unfortunately, it probably seems like it happens more often than it actually does for me, because I get so many calls on this.
Right.
And just today, I've already gotten 3 different calls on this issue, from 3 different clients. So it happened for me. It seems like it happens all the time, but maybe for an individual provider, maybe it doesn't happen all the time.
If a provider does get audited like that,
Yes.
does that mean they're kind of on the blacklist in a sense, and the insurance company is now going to keep a closer eye on them? Or
so that's a great question. And so why do providers even care, right? If you get this letter saying, hey, we overpaid you, we want some money back, why should the provider even pay attention to it? Should they, could they just be like, I'm not paying that money back and just forget about it? And unless we're talking about a lot of money, where we're talking about some kind of egregious issue, some fraud scheme, it's rare that the insurance company is going to file a lawsuit. I mean, certainly they certainly could, but it's rare. I mean, it's got to be a lot of money, and it's got to be something that the insurance company really feels strongly about, that they've really been wronged. The run-of-the-mill overpayment, the insurance company's not going to file a lawsuit over that. So why does the provider even care then? Well, what the insurance company will do instead is you said the word blacklist, something kind of like that. They'll flag providers, and what some insurance companies.
Hey,
All the other claims.
John, I don't know if it's on my end or your end, but your audio is cutting off a little bit. So maybe if you can repeat the last two sentences, that'd be helpful.
Sure. So it's rare that a insurance company would file a lawsuit against a provider, but what's more common is that the insurance company will flag the provider,
Okay.
put them on essentially what you described as a blacklist, where the provider's claims will be automatically denied by the insurance company. So if you've now been flagged because of an overpayment, then future claims that you're submitting to that same insurance company
Right.
are just not going to get paid. They're just going to sit there.
Mhm.
And that's how they will that's how the insurance companies will incentivize providers to come to the bargaining table and resolve that overpayment.
Mhm.
They might also offset payments. So the insurance company might just pull the money that they believe they're owed out of other claims,
Wow.
which is a very controversial practice, which has
Yeah.
been challenged in court. And there's some good case law out there for providers where we argue, no, insurance company, that's illegal. You can't take money out of Plan A to pay yourself for some overpayment involving Plan B, because
Right.
now you've denied benefits to somebody in Plan A who had nothing to do with this overpayment dispute. So that's a controversial practice, but
That
something
practice still happens though?
absolutely still happens. Absolutely.
Wow.
Yeah. And then, of course, depending on what the issues are, if there's some pretty serious issues, if there's a larger investigation going on that the provider has been kind of sucked into,
Mhm.
ignoring an overpayment issue could be a bad idea if suddenly this investigation that the insurance company is conducting turns into a criminal investigation or some kind of civil false claims act investigation. Those are without getting into all the details of what that means.
Right.
It's bad. You don't want to no provider wants to be in that type of situation. So anyhow, you can't ignore overpayments. It's not a good idea.
What if the provider provided a legitimate service and it was a legitimate claim, and now the insurance company's coming back to them and say that we want to look at this and get a portion of it back? What kind of recourse does the provider have? And are they in jeopardy of kind of having that issue with them later on? They're going to get audited again.
Yeah. So yes,
Providers
definitely have recourse, and the answer to that question is going to somewhat depend on the provider's relationship with the payer. And again, I want to sort of take Medicare and Medi-Cal and government payers off the map for the time being, because that's really a separate discussion. So just for purposes of commercial private insurance companies, the first question I'm always going to ask is, are you contracted with that payer or not? Are you in network or are you out of network? Because that will determine two things. It'll determine what theories the insurance company has against you. If you're in network with the insurance company, then they've just got contract rights. All they've got to do is point to their contract with you and say, no, we get to come and collect this because the contract says we can. You agreed that we could do this, but generally there's going to be some kind of appeal process, some kind of dispute resolution process built into the contract that the provider can avail themselves of. Whereas when it's out of network, it gets more tricky and a lot more interesting for me in terms of the various arguments that can be made, because the out of network provider has no contract. They're not contractually bound to the payer in any way.
Yeah.
And so the payer is going to be relying on common law theories such as just misrepresentation, fraud. There are statutory rights that insurance companies have out there, depending on the type of insurance plan you're dealing with. And again, I don't want to get too into the weeds on all that, but for example, if you're dealing with a fully insured product that's regulated by the California Department of Insurance, then there are provisions in the insurance code that will give the insurance company the right to demand refunds if they've overpaid you. But that, again, then it gets into the question of does the provider have any rights to defend themselves? And yes, absolutely, of course they do. There's a lot of different arguments that a provider could make. One thing, provider could defend on the merits and say, no, you're claiming my services were medically unnecessary. I dispute that. I did render the services. Here's all the documentation that supports the medical necessity of my services and XYZ. And that can get very clinical, that can get very factual. It could be a situation where the insurance company is saying, yeah, we paid you on this claim for patient Joe Smith. Well, it turns out that Joe Smith, his insurance policy terminated a week before you provided those services. So sorry, Joe Smith had no insurance coverage at the time you provided those services. So even though we paid it by mistake, we subsequently found out that policy was terminated. We want our money back.
That's a good thing. What happens in a situation like that? That's a very good point. Because the doctor's office still doesn't know, obviously, the provider doesn't know.
Absolutely, you're absolutely right. Yeah. So in that situation, providers have pretty good defense. I mean, they can say, well, wait a minute, because most providers, before they actually provide the care,
right,
they want to find that out. They want to, I'm sure you've been to the doctor before. They always ask about the insurance information.
Right.
So they're contacting the insurance company to verify benefits. If a prior authorization is required for the services, they're gonna get that prior authorization. So there's some legwork the provider's doing, except in the emergency context, but just regular scheduled services. There's some legwork that the provider is going to do to make sure that if they provide services to that member, they're going to get paid. And if the insurance company says, no, this Joe Smith has active benefits coverage, coverage is good, and the provider moves forward with rendering services, then they've rendered services in good faith, in reliance on information provided by the insurance company. So in that situation, the courts, California and most states, have pretty uniformly held that, sorry, insurance company, you may have made a mistake, but you're going to have to bear the burden of that mistake. That's on you. You're in a better position to avoid that mistake than the provider is.
And the providers, I'm assuming, have to log this call to make sure they've got like documentation, an audit trail of it.
Yeah. 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 Usually there's most providers. Well, these phone calls are often recorded, and there's usually a reference number. But providers always fill out some form. It's called a verification of benefits form, and they'll have lots of different little questions that they want to ask. They'll fill them all out, and that's proof, or that's not proof, but it's evidence. It's evidence that this phone call occurred and that the insurance company representative made a representation. So for me as a lawyer, if I have that, I mean, that to me is an easy case. That's not a case where I'm real worried that the insurance company is going to have a strong meritorious claim.
Okay.
And then there's other defenses, time bars. I mean, again, I don't want to get too much in the weeds, but insurance companies, just to stack a statute of limitations, about 1 year for them to claw back money on a claim that they've paid. So but from the time they pay it, they got 1 year to assert that overpayment, with some exceptions, of course. If it actually is fraud, then the 3-year fraud statute of limitations for fraud is 3 years. So there's some other additional defenses that a provider can raise. It kind of depends. It really depends on the circumstances.
So let's assume that a provider is listening out there, and they get this letter from the insurance company. What are some of the steps that they should be taking in response to this letter? And also, at what point do they engage an attorney like you to come and kind of help them out? I'm assuming there's a de minimis amount that they have to justify it with.
Yeah. Well, I would say the first step is take any audit by an insurance company very seriously. So before it even gets to the point of receiving a letter that demands money back or demands a refund, like I said, typically you're part of some post-payment audit, and the first indication that you're part of that audit is when the payer reaches out and asks for records. They'll give you a list of patients, dates of service, and say, all right, we want all the records regarding these patients. That says right there, okay, your services are under review. It's a very good chance that this insurance company is going to assert an overpayment. And something's put you on their radar. And that, again, we could spend a lot of time talking about what might put you on a payer's radar, but assume something's put you on their radar. Maybe your charges are high. Maybe you've had a lot of maybe your volume is kind of shot up all of a sudden. The payers have very sophisticated data analytic systems, and they have flags going up in their systems. And so somehow you've triggered a flag, and now they want to do an audit of you. So the first thing is take those audits very seriously. Get the right people staffed on them right away. You don't necessarily need to call an attorney as soon as you're in an audit, but you need to get your biller involved, whether it's an in-house biller or a outside billing company. You need to get whoever the primary clinician is for that particular patient. You want to get those clinicians involved just to make them aware of what's going on. You need to form a team for responding to the audit and making sure you've got an action plan. If you're worried, if you think, you know what, this is a lot. This is a long list of patients here, and because if you get that list, you're gonna go back and you're gonna check. You're gonna see, okay, is there something going on here? There's something that we missed.
Right.
If you think it's a problem, consider getting counsel involved early. Even before you submit the records back to the insurance company, because maybe you need counsel to review the records also to see if there's something going on that is going to turn into a larger, more problematic investigation. So that's one step. I would say the second step is get a clear picture of your standing. I mean, the provider's standing with that particular payer. Is this a payer that you're contracted with? Is this an out-of-network payer? Do you have a history of disputes with this payer? Is this a pattern of overpayments that you're seeing? Do you have a bunch of unpaid claims or underpaid claims as payer? So maybe I've seen this happen where the provider is really the one who's owed a lot of money, and they just haven't really been paying attention to it. And they go and look. They say, "Wow, this payer owes us $1 million, all in all for that past year," and now they're hitting us with an overpayment. It's almost like the payer's doing something preemptively to try to come after you before you have a chance to really focus on the fact that you're owed a bunch of money. So you need to figure those things out early, because you might be the one that's actually going to go on the offense.
Interesting. All right. So we've been talking about. Oh, sorry. Go ahead.
Well, I was saying just a very important step, of course, if you do get hit with the overpayment, is make sure you appeal, challenge that overpayment in writing. It's not good enough to pick up the phone and call some claims representative and ask questions. You've got to put something in writing. These various defenses I talked about, get those in writing. Support your appeal with records and evidence. If you do have any counterclaims, meaning if there's unpaid claims or underpaid claims, assert those. Get the patient support if you can. It often depends on the relationship with the patient, but at the end of the day, if services are not covered, you might have the right to go after the patient for any monies that you have to pay back to the insurance company. So it's a good idea to get the patients involved and get their support early on, because patients can be actually the best advocates, and that the patients are ultimately the customer, the insurance company. So that's why I recommend that. And then, hopefully you can get into a settlement dialogue with the payer, invite them to meet with you, set up in-person meetings if you can. Right nowadays with the pandemic, it's a little more challenging, but, doing Zoom, but really, have that dialogue with the payer to understand what's going on, and be ready to do what's called a corrective action plan. Meaning, if there are some problems with your billing, with your coding, with maybe you're not, maybe your documentation has deficiencies. Maybe you're not complying with certain medical necessity guidelines that the payer requires. Be ready to put into writing some corrective actions that, as a provider, you're agreeing to take to resolve that overpayment and things that are kind of you're going to do training on internally to make sure in the future you're not going to run into those problems again with that payer.
Okay. Obviously, this is a very complicated subject matter, so we can't get really deep into the weeds on any of this stuff.
Yeah, I know.
Up until now, we've been talking about really the reactive part of it. Let's talk a little bit about the proactive part to kind of close things off and finish the kind of conversation. Is what are some things that providers can do to be proactive to ensure that they can minimize the risk of these audits? Obviously, you can't avoid it, but if you can minimize it, that'd be great. If those are maybe some good tips that you can give providers out there.
Yeah, absolutely. That's a great way to close this. Yes, be proactive in developing your program, your facility around compliant policies and procedures that will help you be less likely to become a target of an overpayment or an audit. And I realize that's easier said than done, and that payers are always going to try to claw back money because they're let's be frank, they're not really in the business of paying claims. They're in the business of selling insurance and collecting premiums, right? But nonetheless, avoid risky practices. Now, there's a lot of different risky practices that a provider can take in healthcare, and I don't want to get into all of them. I can't even get into it. I can barely scratch the surface. But a lot of something I see a lot, and this comes up in the out-of-network context, is when you're out of network, you're competing with in-network providers. So you're trying to get patients in the door. Patients are always being counseled, hey, stay in network, don't go out of network. It's going to cost you more to go out of network. The out-of-network provider can balance bill you, et cetera, et cetera. And so what a lot of out-of-network providers will do is they will waive the patient's cost share obligations. They'll say, look, come to me. I won't even charge you your co-insurance. I won't charge you a deductible. I'm just going to look to your insurance for payment. Cost share. Insurance companies hate that, and they've been going after it very aggressively in the last 5 years or so, probably a little longer. And so that's an example of a risky practice. Just don't do that, because they will actually go out and audit patients. They'll actually send out questionnaires saying, hey, were you asked to pay any money? How much did you pay? Did you ever receive an invoice? And that could be a trigger of an audit. That can be a trigger of a fraud investigation, frankly. So avoid risky practices. Pay attention to evolving payer guidelines. Again, it's easier said than done, especially if you're in network. You're going to get the payer guidelines. If you're out of network, you have to search them out. You've got to routinely check the payer websites for policy and guideline updates.
Which was a real pain in the butt, by the way. It's not an easy thing to do. Which is a real pain in the butt. It's not an easy thing to do.
Sure. Yeah, exactly. No, it's you have to sort of put it on your calendar, and then you've got to go and dig through their websites, which are full of information. And it's sometimes be like finding a needle in a haystack. But you have to make efforts to do that. I think billing companies are the ones who are that should be part of their job. If you use an outside biller, or if you have an in-house biller, that should be part of their job. Is to stay on top of payer guidelines. And then documentation. I mean, every single post-payment audit, overpayment dispute I've ever been involved in, the insurance company's alleged poor documentation. And while, you can quibble about, well, this I wasn't dotted and this T wasn't crossed, so big deal. We still rendered the services. There's this old adage in healthcare: if it's not documented, it didn't happen. And you've got to abide by that, because if you've got documentation problems, if you just use a bunch of templates and everything just looks exactly the same, only thing that's different is the patient's name and the date of service, payers, they're going to jump all over that, and they're going to use that as evidence to assert that the services are either not being rendered or are not necessary, or that you can't prove that they were rendered. So documentation is one of those things where providers can do a lot of upfront self-auditing of their own clinical documentation, self-auditing of their own billing policies and coding policies. All of those things will help them. There's a ways to be proactive to avoid falling onto a payer's post-payment audit and just overall operating a compliant facility, not a compliant medical practice. That's the most important thing. So I hope that's helpful.
Yeah, that was absolutely helpful. Very, very informative. I mean, just one last question before we kind of close off is, are there any branches of medicine that tend to have a higher risk? Like, for example, like orthopedics or psychiatry or radiology, are there certain branches of medicine that tend to be a little more riskier in this area, or it doesn't really matter?
Yeah, I've seen overpayments all over the place. It's hard for me to say that I've seen them more with a particular specialty. I tend to see them more with surgery claims.
Mm-hmm.
So I think maybe surgeons get hit with these a little more often.
Is it because it's more of a high dollar amount? Is that probably why?
Might be because it's more a high dollar amount, higher dollar amounts. And I think historically, there was a little more room for fraud and waste in the surgery world, where you've got doctors doing procedures that are questionable in terms of their necessity.
Yeah.
So that's definitely an issue. Lately I've been doing a lot of work in the drug and alcohol addiction recovery space, and I see overpayments there all the time. And I think that's probably indicative of the insurance companies. They really don't want to pay for mental health care. I mean, that's a whole nother conversation.
Yeah.
The fact that what's called mental health parity, and trying to get insurance companies to abide by the federal and state requirements, and they can't, because it's very expensive.
It's also subjective as well. I mean, if you have like a broken leg, I mean, it's a broken leg.
Exactly. It's very expensive. It can be quite subjective. And it's kind of hard to say when the person's been, cured, right? I mean,
right.
If you have a broken leg, you can sort of say, okay, yeah, my leg is fixed. I'm able to walk again. But with mental health, with addiction, it's kind of it can be a cycle. I mean, people can cycle in and out of treatment facilities for years.
Yeah.
For years. And if somebody goes into a 30-day rehab program, that's a big bill for the insurance company. So they really target that very, very aggressively, because it's a lot of claims, and they're very expensive claims. So that's an area that I've been seeing a lot of work in.
Okay. Well, hopefully some of our viewers are in that industry and may need your services. John, thank you so much for joining us. This was enormously informative, and I will put your contact information below. If there's anything else that you think is worthwhile for our listeners to know about you, obviously send it over to me. I'll put that as well. If you want to get a hold of John, we'll have his contact information. And John, any closing thoughts before we kind of wrap up here?
I just want to thank you very much for letting me speak to your audience, and I think it's an interesting topic. It's one that's not going away anytime soon, and I think that it's a problem for providers, a problem for patients, and it's something that I think our overall healthcare system needs some work to avoid some of these very complicated reimbursement issues. So, on that note, I'll just say, hopefully there'll be some legislative fixes in the future that will help us, get past some of these issues.
Yeah, let's hope so. I don't know what the legislative landscape looks like in the near future, but let's hope that that's the case. So thank you again.
Thank you.